I'm Mary Schuster, Chief Product Officer and EVP of Regulatory Affairs with RamQuest, here to talk to you today about the new closing disclosure form from the CFPB. In the past, federal law required two different disclosure forms to be provided to consumers at or shortly before their loan closing. The information on these forms, known as the final TIL and HUD-1, was overlapping and often inconsistent. Consumers often found the forms confusing. The Dodd-Frank Act directed the Consumer Financial Protection Bureau, the CFPB, to integrate these mortgage loan disclosures into a new, single, consolidated disclosure form. As a result, the closing disclosure form is a 5-page form that is due to the borrower for review 3 days prior to the closing or settlement in an escrow state. It is due to the seller not later than the day of closing or settlement. The lender or creditor is responsible for delivering the closing disclosure, or CD, to the borrower, also the consumer, but creditors may engage the services of a settlement agent to provide the CD so long as they comply with the provisions of the rule. The rule creating these new requirements is known as the Integrated Mortgage Disclosure Rule, or TRID, and it applies to most closed-ended mortgage transactions except home equity lines of credit, reverse mortgages, and true mobile home loans, when the dwelling is not attached to the land, or seller financing where the creditor makes 5 or fewer mortgages in a year. Let's take a look at the first page of the closing disclosure form to see what information is presented first to the borrower.